Good evening, everyone. Tonight, I will present the core powers of the Securities and Exchange Commission under the Securities Regulation Code, Republic Act Number 8799. Part 1, SEC's General Authority. Subsection A, Corporate Supervision. The SEC has absolute jurisdiction and supervision over all corporations, partnerships, and associations granted primary government franchises or licenses. Subsection B, Policy and Legislative Advice. It is empowered to formulate policies, advise Congress, and propose new legislation amendments related to the securities market to ensure effective regulation and investor protection. Part 2, Market Gatekeeping and Oversight. Subsection C, Registration Veto Power. The SEC has the authority to approve, reject, suspend, revoke, or require amendments to registration statements and licensing applications. This is its control over who enters and operates in the securities market. Subsection D, Investigative and Supervisory Power. It is empowered to regulate, investigate, and supervise all market activities to ensure compliance with relevant laws and maintain market integrity and investor protection. Part 3, Market Infrastructure and Enforcement. Subsection E, Supervising market infrastructure. The SEC can supervise, monitor, suspend, or even take over exchanges, clearing agencies, and other self-regulatory organizations, SROs, to ensure their fair and efficient operation. This prevents market collapse. Subsection F, Enforcement and Sanctions. This is the SEC's enforcement power, allowing it to impose sanctions, fines, suspensions, bars for the violation of any laws, rules, or orders. This gives the rules their authority and ensures accountability.
Part 4.
Rulemaking and external support. Subsection G, Rulemaking and Guidance. The SEC has the power to prepare, approve, amend, or repeal the governing rules and to issue official opinions guidance. It is both the market rulemaker and the chief interpreter of the law. Subsection H, Enlisting aid. It can deputize and enlist the aid of any civil or military enforcement agencies, as well as private institutions, to effectively implement its powers and enforce its orders nationwide.
Report on corporation law cases transferred to the Regional Trial Court. Under Republic Act Number 8799, also known as the Securities Regulation Code, certain jurisdictional powers once held by the Securities and Exchange Commission over intracorporate disputes were transferred to the RTC, designated as special commercial courts. This transfer aimed to streamline the resolution of commercial disputes, including those involving corporations, partnerships, and associations. Legal basis. Section 5.2 of Republic Act Number 8799 provides the Commissioner's jurisdiction over all cases enumerated under Section 5 of Presidential Decree Number 902-A is hereby transferred to the Courts of General Jurisdiction or the appropriate regional trial court. Thus, effective August 8, 2000, intracorporate cases and other corporate controversies were to be filed and heard before the RTC, not the SEC. Types of corporation law cases transferred to RTC. The following types of cases were originally under Section 5 of PD number 902-A but were transferred to the RTC. First, intracorporate disputes, including controversies between and among stockholders, members, or associates, and between stockholders and the corporation itself. Second, election or appointment controversies in corporations, partnerships, or associations. Derivative suits filed by stockholders in the name of the corporation. Fourth, controversies in the management of corporations, such as disputes involving directors, trustees, or officers. Fifth, dissolution of corporations and appointment of receivers or liquidators. Role of the Regional Trial Courts, Special Commercial Courts. The RTC, acting as a special commercial court, now exercises exclusive jurisdiction over these corporation law cases. The Supreme Court, through Administrative Matter Number 001103-SC, designated specific RTC branches in key cities like Manila, Quezon City, Makati, Cebu, and Davao to handle these cases. The RTC's jurisdiction includes issuing injunctions, receivership orders, or liquidation decrees, deciding corporate election contests, and determining ownership or rights over corporate shares. Relevant Supreme Court decisions: Union Glass and Container Corporation versus SEC GR number 1777655 of June 30, 2008. The court reiterated that after Republic Act 8799, the SEC no longer exercises jurisdiction over intracorporate controversies. Speed Distributing Corp versus Court of Appeals GR number 149351 of April 8, 2005 clarify that RDCs now handle all intracorporate disputes previously under SEC jurisdiction. Real versus Sango Philippines Incorporation, JR number 168757, January 19, 2011, affirmed that RDCs sitting as a special commercial courts have exclusive jurisdiction over disputes arising from corporate relationships. Mating Industrial and Commercial Corp versus Chorus GR number 157802 of October 13, 2010 explained the test of relationship and test of nature of controversy to determine if a case is intracorporate and therefore under the RTC's special jurisdiction. Summary of effect. Before Republic Act 8799, there is jurisdiction over intracorporate cases, Securities and Exchange Commission, nature of jurisdiction, quasi-judicial, legal basis, Presidential number 902-A, the purpose is regulation and adjudication. But after Republic Act 8799, jurisdiction over intracorporate cases by the RDC or a special commercial court, nature of jurisdiction or judicial, legal basis Republic Act number 8799 section 502, purpose judicial resolution and due process. Conclusion: the transfer of jurisdiction from the SEC to the RTC under Republic Act 8799 marked a major shift in Philippines corporate litigation. This change enhanced judicial independence, ensured due process, and centralized the handling of corporate disputes within the judicial system through special commercial courts. Consequently, corporation law cases, particularly intracorporate controversies, are now properly lodged before the regional trial courts, ensuring more consistent and judicially supervised resolution of corporate conflicts. Thank you, and that's me, Cherise Ramientos, reporting this.
So good evening, attorney. Good evening, everyone. So I will be discussing the definition of terms. So first, securities. So when we say securities, these are the shares, participation of interest in a corporation or in a commercial enterprise or profit-making venture and evidenced by a certificate, contract, instruments, whether written or electronic in character. So these includes shares of stocks, bonds, debentures, notes, evidences of indebtedness, asset-backed securities, investment contracts, certificates of interest or participation in a profit share agreement, certificates of deposit for a future subscription, fractional and undivided interest in oil, gas, or other mineral rights, derivatives like option and warrants, certificates of assignment, certificates of participation, trust certificates, voting trust certificates, or similar instrument, proprietary or non-proprietary membership certificates in corporations, and other instruments that may be in the future be determined by the Commission. Another term is issuer. So is the originator, maker, obligor, or creator of the security. Next is broker, is a person engaged in the business of buying and selling securities for the account of others. Next term is dealer. So means many person who buys, sells securities for his or her own account in the ordinary course of business. Next term is associated person of a broker or dealer. So this is an employee, therefore, whom directly exercises control of supervisory authority, but does not include a salesman or an agent or a person whose functions are essential. So next is insider. So It means this includes the issuer, a director or officer, or any person performing similar function of or a person controlling the issuer gives or gave him access to material information about the issuer or the security that is not generally available to the public. A government employee, director, or officer of an exchange clearing agency and or self-regulatory organization who has access to material information about an issuer or a security that is not generally available to the public, or a person who learns such information by a communication from any foregoing insiders. So next term is pre-need plans. So these are contracts which provide for the performance of future services of or the payment of future monetary consideration at the time actual need, for which plan holders pay in cash at installment at stated prices with or without interest or insurance coverage, and includes life, pension, education, retirement, and other plans, which the commission may from time to time approve. Next term is promoter. So this is a person who, acting alone or with others, takes initiative in founding and organizing the business or enterprise of the issuer and receives consideration therefore. Next term is prospectus. This document made by or on behalf of an issuer, underwriter, or dealer to sell or offer securities for sale to the public through registration statement filed with the commission. Next is the registration statement. Is the application for the registration of securities required to be filed with the commission. Next term is salesman. Is a natural person employed as such as an agent by a dealer, issuer, or broker to buy and sell securities. Next is uncertificated security. This is security evidenced by electronic. So, thank you so much.
Basic rules regarding registration of securities. Section 8.1. Securities shall not be sold or offered for sale or distribution within the Philippines without a registration statement duly filed with and approved by the Commission. Prior to such sale, information on the securities in such form and with such substance as the Commission may prescribe shall be made available to each prospective purchaser. The key principle under subsection 8.1 is that no sale or offer of securities in the Philippines is allowed unless a registration statement has been filed with and approved by the SEC. The issuer must provide prospective purchasers with required information before the sale. This helps ensure full disclosure, investor protection, transparency of securities being offered. It serves as a gatekeeping mechanism so that only properly vetted securities are offered to the public. For example, if a company wants to issue shares or bonds to the public, they must register those securities first, otherwise, selling would be illegal. Section 8.2. The Commission may conditionally approve the registration statement under such term as it may deem necessary. The Commission has discretionary power to approve a registration statement conditionally, meaning the registration may be approved but subject to certain terms, restrictions, or conditions the Commission imposes. So, even after filing, the issuer may be required to fulfill certain conditions, for example, amend disclosures, provide additional guarantees, etc., before or during the offering. This gives the regulator flexibility to tailor the approval to the particular facts of the case, enhancing investor protection. Section 8.3. The Commission may specify the terms and conditions under which any written communication, including any summary prospectus, shall be deemed not to constitute an offer for sale under this section. This subsection deals with communications or written materials about securities offerings like prospectus, advertisements, letters, etc. Normally, communications that solicit investors might be considered offers for sale, which would trigger the registration requirement under subsection 8.1. However, the Commission can define that if certain conditions are met, a communication will not be treated as an offer for sale, meaning it won't automatically trigger full registration regime. This provides flexibility to allow certain informational materials under regulated circumstances without treating every piece of marketing or communication as an immediate offering requiring full registration.
Good evening once again. This is Gilgoric Ngoho, and I am assigned to report the registration of securities, Section 8.4. Under Section 8.4, it states that a record of the registration of securities shall be kept in register securities in which shall be recorded orders entered by the Commission with respect such securities. Such register and all documents or information with respect to the securities registered therein shall be open to public inspection at reasonable hours on business days. So it means that it ensures that all information about registered securities, including official actions by the Commission, is properly recorded and open for public inspection. This helps promote accountability, trust, and informed decision-making in the securities market. Next slide. Under Section 8.5, it states that the Commission may audit the financial statements, assets, and other information of firm applying for registration of its securities whenever it deems the same necessary to ensure full disclosure or to protect the interest of the investors and the public in general. The purpose or the essence of this section is protection and integrity. It ensures that investors and the public get accurate and complete information before investing. By allowing the Commission to verify a company's claims, it helps prevent fraud, misleading disclosures, and financial manipulation, thereby safeguarding investor trust and maintaining a fair and transparent market. It also means that the Commission has the power to examine or audit a company's financial records, assets, and other information when that company is applying to register its securities. The goal is to make sure that the company is being honest and transparent about its financial situation.
The next topic is Section 9.2, Authority of the Commission. Section 9.2 of the Securities Regulation Code provides that the Commission may, by rule or regulation after public hearing, add to the foregoing any class of securities if it finds that the enforcement of this code with respect to such securities is not necessary in the public interest and for the protection of investors. The reason for this is the issuer is a trusted and regulated officer. What transactions are exempt from the registration requirement under Securities Regulation Code? Section 10.1 of the Securities Regulation Code provides that the requirement of registration under subsection 8.1 shall not apply to the sale of any security in any of the following transactions. First is at any judicial sale or sale by an executor, administrator, guardian, or receiver, or trustee in insolvency or bankruptcy. Second one is by or for the account of a pledge holder or mortgagee or any of a pledge lien holder selling or offering for sale or delivery in the ordinary course of business and not for the purpose of avoiding the provision of this code. To liquidate a bona fide debt, a security pledged in good faith as a security for such debt. Third is an isolated transaction in which any security is sold, offered for sale, subscription, or delivery by the owner, therefore, or by his representative for the owner's account. Such sale or offer for sale, subscription, or delivery not being made in the course of repeated and successive transaction of a like character by such owner, or on his account by such representative, and such owner or representative not being the underwriter of such security. Fourth one is the distribution by a corporation actively engaged in the business authorized by its articles of incorporation of securities to its stockholders or other security holders as a stock dividend or other distribution out of surplus. Fifth one is the sale of capital stock of a corporation to its own stockholders exclusively where no commission or other remuneration is paid or given directly or indirectly in connection with the sale of such capital stock. Sixth one is the issuance of bonds or notes secured by mortgage upon real estate or tangible personal property when the entire mortgage together with all the bonds or notes secured thereby are sold to a single purchaser at a single sale. Seventh one is the issuer and the delivery of any security in exchange for any other security of the same issuer pursuant to a right of conversion entitling the holder of the security surrendered in exchange to make such conversion, provided that the security so surrendered has been registered under this code or was, when sold, exempt from the provision of this code, and that the security issued and delivered in exchange, if sold at the conversion price, would at the time of such conversion fall within the class of securities entitled to the registration under this code. Upon such conversion, the par value of the security surrendered in such exchange shall be deemed the price at which the securities issued and delivered in such exchange are sold. 8 is broker's transaction executed upon customers' orders on any registered exchange or other trading market. 9 is subscriptions for shares of the capital stocks of a corporation prior to the incorporation thereof or in pursuance of an increase in its authorized capital stocks under the corporation code when no expense is incurred or no commission, compensation, or remuneration is paid or given in connection with the sale or disposition of such securities, and only when the purpose for soliciting, giving, or taking of such subscription is to comply with the requirements of such law as to the percentage of the capital stock of a corporation which should be subscribed before it can be registered and duly incorporated, or its authorized capital increase. 10th one is the exchange of securities by the issuer with existing security holders exclusively where no commission or other remuneration is paid, given directly or indirectly for soliciting such exchange. The sale of securities by an issuer to fewer than 20 persons in the Philippines during any 12-month period. The sale of securities to any number of the following qualified buyers. First is the bank. Second one is registered investment house, insurance company, pension fund or retirement plan maintained by the government of the Philippines or any political subdivision thereof or managed by a bank or other persons authorized by the Bangko Sentral to engage in trust functions, investment company or such other persons as the commission may rule by determined as qualified buyers on the basis of such factors as financial sophistication, net worth, knowledge and experience in financial and business matters or amount or assets under management. The reason for this is limited character of offering. Second one is mandated by law. Stock dividends declared. And fourth one is transaction is such that registration of the securities is unwarranted.
Wala. Section 10.2 of the Securities Regulation Code provides that the Commission may exempt other transactions if it finds that the requirements of the registration under this code is not necessary in the public interest or for the protection of the investors, such as by reason of the small amount involved or the limited character of the public offering. This means that the SRC grants the Securities and Exchange Commission the authority to exempt certain transactions from registration requirements if it determines that registration is not necessary for public interest or investor protection. This is typically based on factors like small amount involved or a limited public offering. Authority to exempt. The SEC has the power to create exemptions for specific types of transactions. Criteria for exemption. Exemptions can be granted if the transaction is small in amount or other public offering is limited in character. The goal is to avoid unnecessary registration requirements when it is not needed for the public interest or to protect investors. Section 3.2 of the Securities Regulation Code provides that any person applying for an exemption under this section shall file with the Commission a notice identifying the exemption relied upon on such form, and at such time as the Commission by rule may prescribe, in which such notice shall pay to the Commission fee equivalent to the 1/10 of the 1% of the maximum value aggregate price or issued value of the securities. This means that anyone seeking an exemption must file a notice with the SEC using the prescribed form and time frame and pay a fee equivalent to 1/10 of the security's maximum aggregate price or issued value. This section outlines the administrative and financial requirements for individuals seeking an exemption from certain securities regulations under the SRC. Requirements for exemption. File a notice. Applicants must submit a notice to the SEC that specifies the exemption they are relying on. Then follow SEC rules. The notice must be submitted on the specific form and within the time frame set by the SEC. And then pay a fee. A fee of 1/10 of the 1% of the security's maximum aggregate price or issue value must be paid to the SEC.
Next topic under RA 8799 is the prohibitions and fraud, manipulation, and insider trading. Section 24 talks about the devices and practices of manipulation of security prices identified under the Securities Regulation Code. Under Section 24.1, it talks about manipulation of security prices, devices, and practices. It shall be unlawful for any person acting for himself or through a dealer or broker, directly or indirectly, to create a false or misleading appearance of active trading in any listed security traded in exchange of any other trading market, such as by affecting any transaction in such security which involves no change in the beneficial ownership thereof, or by entering an order or orders for the purchase or sale of such security with the knowledge that a simultaneous order or orders of substantially the same size, time, and price for the sale or purchase of any such security has or will be entered by or for the same or different parties, or by performing similar acts which there is no change in beneficial ownership, or it is to effect alone or with others a security or transactions in securities that raises the price to induce the purchase of a security, whether of the same or different class of the same issue, or of controlling, controlled, or commonly controlled company by others, or creates active trading to induce such a purchase or sale through manipulative devices such as marking the close, painting the take, squeezing the float, hype and dump, boiler room operations, and such other similar devices. And C, to circulate or disseminate information that the price of any security listed in an exchange will or is likely to rise or fall because of manipulative market operations of any one or more persons conducted for the purpose of raising or depressing the price of the security for the purpose of inducing the purpose of sale of such security, or to make false or misleading statement that disrespect to any material fact which he know or had reasonable ground to believe was so false or misleading for the purpose of inducing the purchase or sale of any security listed or traded in an exchange, or to effect either alone or others any series of transactions for the purchase and or sale of any security traded in an exchange for the purpose of pegging, fixing, or stabilizing the price of such security, unless otherwise allowed by this code or by the rules of the Commission. For example, Under the law, the wash sales, that's transactions where there is no real change in beneficial ownership. For example, a trader buys and sells the same stock to themselves to make it appear that the stock is actively traded. So other is the match orders, by entering an order to buy or sell knowing that a matching order of the same size or price will be entered by another person, so there is a collusion. For example, the two investors agree to buy and sell the same shares to each other to show fake demand. And then next is the example is price manipulation acts. For example, the acts done to raise or depress the price of a security to induce others to buy or sell. For example, painting the tape by executing a series of trades to give the illusion of heavy trading activity, or marking the close by making. Next is the section 24.2, which talks about the use of deceptive devices or contrivances. The provision says that no person shall use or employ in connection with the purchase or sale of any security any manipulative or deceptive device or contrivance. Neither shall any short sale be effected nor any stop-loss order be executed in connection with the purchase or sale of any security except in accordance with such rules and regulations as the Commission may prescribe as necessary or appropriate in the public interest for the protection of investors. So it states there that it is unlawful for any person in connection with the purchase or sale of the security to use or employ any manipulative or deceptive device or contrivances. Examples under the law is the short sales. This is when the selling securities that the seller does not own, hoping to buy them back later at a lower price. This is allowed only if done according to the SEC rules to prevent abuse, otherwise it's manipulation. Next example is the stop-loss orders. For example, this act is orders to sell a security when it falls to a certain price. This is a misuse or fake placement of these orders to influence prices is prohibited. Or any other manipulative act, any device, scheme, or artifice to defraud investors or distort market prices not covered by other specific prohibitions.
Good evening, attorney. Good evening, classmates. I am Edna M. Esperta, and I am going to continue the report with the acts that are considered unlawful with respect to the purchase and sale of securities. So, Section 26 of the Securities and Regulation Code is a prohibition against fraud in connection with the buying or selling of securities such as stocks, bonds, or other investment instruments. It states that it is illegal for anyone to use deceptive, misleading, or dishonest practices in any transaction involving securities in order to protect investors and maintain fairness and integrity in the securities market, meaning no one is allowed to use tricks or schemes to cheat investors, like creating fake investment opportunities or manipulating stock prices. No one can make false statements or hide important facts about the company, such as lying about the company's financial health, and basically no one should do anything that causes fraud or deceit. The law demands honesty, transparency, and fair dealings in all securities transactions. Section 27, on the other hand, is about the duties of an insider in case of trading securities. So, Section 27 defines and prohibits insider trading or the unfair use of confidential, non-public information in securities trading. Insider trading is an illegal act of an insider to buy or sell securities of a company while possessing material information not yet available to the public. So, who is an insider? An insider is a person with access to confidential company information such as directors, officers, employees, or anyone with a special relationship to the company. Section 27.1 provides for exemptions where the insider is not liable. So, letter A, the insider must prove that the information was not gained from such relationship, or if the other party selling to or buying from the insider is identified, the insider must prove that he disclosed the information to the other party, or that he had reasons to believe that the other party otherwise is also in possession of the information. However, the general presumption provided under the law is that if an insider or their spouse or close relatives up to the second degree of sanguinity trades after the information came into existence but before it became public, it is presumed that they traded using insider information. This may be rebutted if the insider can prove that they did not know the confidential information at the time of the transaction.
Good evening, everyone. Good evening, classmates. Good evening, attorney. So my report is all about Section 19, tender offers. So this is under Securities Regulation Code. So under paragraph 1, tackles who must make a tender offer. So any person or group acting in concert who intends to acquire 15% of any class of equity securities of a listed corporation or 30% of such equity over a 12-month period. So the criteria for the corporation is that it must have an asset of at least 50 million pesos and at least 200 stockholders, each owning at least 100 shares. So filing requirements. So must file a declaration with the SEC, must furnish the issuer a statement containing information required under Section 17 as prescribed by the Commission. Publication and distribution. All requests, invitations, or tender offers must contain information prescribed by the Commission, must be filed with the Commission and sent to the issuer no later than the first published or given to shareholders. So solicitation rules, any solicitations or recommendation to accept or reject a tender offer must follow rules and regulations prescribed by the Commission. So as to withdrawal of the securities, the depositors may withdraw securities anytime while the tender offer is open if not yet accepted for payment. So after 60 days from the original tender offer, if accepted, unless Commission prescribes otherwise. So pro rata acceptance. So if securities offered, securities decide to be taken up, securities are accepted pro rata. Applies to securities deposited within 10 days after notice of increased consideration. So yeah, variation of tender offer. If the terms of a tender offer are increased before expiration, all security holders whose securities are taken up must receive the increased consideration, even those already accepted before the increase. So under paragraph 2, um, prohibited acts, it is unlawful for any person in connection with a tender offer request or invitation for tenders to first make an untrue statement of material fact, second, omit a material fact necessary to make the statement not misleading, and third, engage in fraudulent, deceptive, or manipulative acts or practices. So the Securities Exchange Commission is empowered to define what constitutes a fraudulent, deceptive, or manipulative acts and prescribe means reasonably designed to prevent such acts and practices. So that ends my report. Thank you for listening.
Good day, everyone. Today I'll be discussing Section 19, specifically Paragraph 2 of the Securities Regulation Code, which talks about tender offers. So, this provision is important because it protects shareholders when there is a potential change in control of a public company. So in this slide, we'll be talking about the prohibited acts in connection with a tender offer, request, or invitation for tenders. So these rules are in place to protect investors and ensure fairness and transparency in financial transactions. So the prohibited acts are it is considered unlawful for any person directly or indirectly connected with a tender offer to number one is to make an untrue statement of a material fact. So this means giving false or incorrect information about something important that could influence a person's decision. So number two is omit a material fact that is necessary to make the statements not misleading. So even if the statements are technically true, leaving out important information that changes the meaning or creates a false impression is prohibited. So number three, the last one is that engage in any fraudulent, deceptive, or manipulative act or practice. So this holds any scheme or action designed to trick, mislead, or take advantage of others during the tender offer process. So now let's talk about the powers of the Securities and Exchange Commission or the SEC. So the SEC is given the authority to protect investors and maintain fair and orderly financial markets. Specifically, it is empowered to do the following. Number one is the SEC can define what actions or practices are considered fraudulent, deceptive, or manipulative. So this means the SEC has the power to determine when an act in the securities market is misleading or harmful to investors. The second one is the SEC can prescribe or establish rules and measures that are reasonably designed to prevent these fraudulent, deceptive, or manipulative acts and practices. So, in other words, the SEC creates guidelines and safeguards to make sure these harmful activities are avoided and punished if they occur. So, through these powers, the SEC ensures transparency, accountability, and trust in the financial system. So, this ends with my report. Thank you, and thank you for listening.